Good afternoon. My name is Carrie Filiberto, and I'm the Senior Director and Counsel of Contracts and Construction Law at the Associated General Contractors of America. Thank you for participating in today's 90-minute webinar. A copy of the PowerPoint presentation will be emailed to you after the webinar. You will have an opportunity to ask questions of our speakers today. Please type your questions in the questions box, and we'll have the speakers address them at the end of the presentation. I would now like to introduce our esteemed speakers, Tim Gibbons and Frank Riggs. Tim is the chair of the construction group at Chambliss, Bahner, and Stophel PC in Chattanooga, Tennessee. He focuses his practice on construction disputes and contract negotiation and drafting. He has lectured extensively on a variety of construction law topics, is a founding member of the Tennessee Association of Construction Counsel, and is listed in the Best Lawyers in America for Construction Law. Prior to attending law school, Tim practiced for 7 years as a licensed architect. Frank is the co-chair of the construction practice group for the Atlanta-based firm of Troutman Sanders. He has been a practicing construction lawyer for over 35 years, representing the interests of owners, contractors, construction managers, designers, and suppliers. He serves as a member of the AGC Contract Documents Committee and the ConsensusDocs Drafting Council. He was named Best Lawyers 2012 Atlanta Construction Law Lawyer of the Year and is a fellow in the American College of Construction Lawyers. He is a graduate of the University of Virginia Law School. And now for a couple of housekeeping slides. Certificates of completion, if you're looking for the AIA CES credits, we'll have information on the final slide of where you email to obtain the form that you will need to submit that. Course description, I won't spend time on this, as you will see in the PowerPoint, and same with learning objectives. I'll have our speakers go straight into those. I wanted to point out briefly, though, one of the differences between ConsensusDocs and the AIA documents are that ConsensusDocs are endorsed by 41 industry associations. AIA contract documents are endorsed by the AIA. And with that, we will turn it over to Frank, I believe, is going to start us off.
Thanks, Gary. Tim and I are pleased to be with you this afternoon to talk about two sometimes very different and sometimes similar approaches to structuring owner-architect agreements for a construction project. You know, we may refer during the course of our discussion to another AIA or ConsensusDocs form or two, but our focus primarily is going to be on the AIA B101 and the ConsensusDocs 240 document. I doubt that there are any standard form agreements that are more often used in the construction industry for establishing owner-architect agreements on traditional construction projects. And so Tim and I are going to try to identify for you some important differences between the two documents and offer some comments on the significance and sometimes relative insignificance of those differences. I should say that if we comment on perceived shortcomings of one document or another with respect to certain issues, we're not suggesting that you not use that document, but I guess we are suggesting that depending on your perspective, whether you are an owner or an architect or have some other position as a stakeholder on a construction project, you may want to look at the documents you choose to use with respect to some of these issues and modify them to fit the particular needs of your project. Tim's going to get us started by talking about document ownership and use issues. Tim, I'll turn it over to you.
Thanks, Frank, and Carrie, the next slide. This is a very technology-driven point. We have only a very short time, and so we'll really only be hitting just the high points. But since certainly both of my topics are technology-driven, I think it is worth at least taking just a few seconds to kind of go through where we are in the technology of producing design documents. Back when I was an architect in the late 1970s and early 1980s, I actually drew drawings by hand with T-squares and parallel bars and triangles and pencils and pins. But in the early 1980s, the advent of CAD began to change that, and we've obviously come far beyond those early CAD stations that, would fill a small room and cost $75,000. The same advances that revolutionized computers have revolutionized design documents. More powerful processors, bigger storage capacity, the costs come down, the capabilities go up. And all this, has happened so quickly, really just within my lifetime, that contracts really are just now beginning to catch up. And the next slide, Carrie, the law will take a little bit longer to catch up, I'm afraid. The competing interest in the ownership of documents are fairly well known. Many owners want to protect their own proprietary information, in particular on highly specialized projects like, as an example, auto assembly plants like Volkswagen has just built up here in Chattanooga, extremely sensitive chemical processing facilities. Sometimes the arrangement, the configuration of spaces and layout of facilities is very much a part of the information that an owner wants to protect. Now, on the other hand, the designers are the author. So they have their authorship interest. They want to be able to protect those as right. The broad category of all these rights is intellectual property. It is interesting to note that sometimes a design itself is a protectable intellectual property right. And I'm dating myself, I realize, by using this example, but some of you may be old enough to remember the photomat kiosk that used to sit in parking lots where, for those of you who remember cameras and film, you'd take your film to be developed. Well, those photomat kiosks were actually copyrighted or trademarked, and there were lawsuits when other people copied those kiosks. So the intellectual property rights in design are not just the copyright, they go beyond that. Now, the next slide, please. In the AIA, the B101, and I'll start on the right hand of this slide, really takes a traditional approach. The architect is the author. The architect and its consultants are the owners of the defined term instruments of service defined in the documents. They retain all of the rights, including the copyrights. ConsensusDocs in the 240 elected to make what is really a fundamental change. It vests ownership of all documents, drawings, data, except for the copyrights. It vests ownership in the owner. And in addition, the owner can also purchase the copyright itself. Now, I want to go back to a point that Frank made earlier. Even this approach, these two approaches that you see in these two documents are often modified. And simply as an example, many of the owners who I have represented have preferred to have all of the intellectual property rights, including the copyright, and we have been asked to define very broadly what those rights are and that the owner has all of them. Again, as Frank mentioned, each of these documents are subject to being modified, and depending on whether you're the architect or the owner or who you represent as an attorney, it's often going to be necessary to do that. Next slide, please. The ConsensusDocs 240, as I mentioned before, already also gives the owner the option of being granted the copyright interest. It's a fill-in-the-box approach. It says, the owner does or does not purchase the copyright and gives you a blank to fill in the amount for the copyright fee. As is important in contracts such as ConsensusDocs, where there are fill-in-the-blank places left, they do include a default position if the parties do not fill in anything. If you leave it all blank, then the copyright stays with the designer. The AIA and the B101, as you see on the other side of the slide, is the traditional approach in which the architect, having all the ownership rights, grants a non-exclusive license solely for certain uses. Next slide, please. Some of the differences between the ConsensusDocs 240 and the AIA B101, the owner under ConsensusDocs can use the documents to complete the project after the owner terminates for convenience if the owner has paid all the sums due. And a very interesting point under ConsensusDocs is that the owner can also use those documents for what's called derivative works. They can use the architect's documents to make other projects. On the AIA side, again, if the owner doesn't pay everything due, it loses its limited license. Next slide. Transmission of documents, just as in the same way that technology has revolutionized the creation of the documents, it's revolutionized how they are transmitted. And again, I really wish we had a lot of time to go through this. The AIA has a separate document called the E201, which is the Digital Data Protocol. It establishes the procedures for transmission and exchange of documents. ConsensusDocs has a separate document called the 200.2, which is the Electronic Communications Protocol Addendum. Like the AIA, it sets forth the procedures and the administrative framework for electronic document transfer. One thing I would say is that the ConsensusDocs 200.2, and I realize you don't have it sitting in front of you there, but I do, and it's a much more detailed document. And it comes out of the gate with a different concept from the AIA, whereas the AIA, you simply append this exhibit, doesn't change any of the other documents. Under ConsensusDocs, when you utilize the 200.2 document, to the extent its terms and conditions are different from all the other agreements, then this 200.2 governs and it controls. That's important to know. Legally and practically. The other thing about the ConsensusDocs is it sets up this regime of people who are involved in the process. You have people, IT administrators are identified for each of the contracting parties, which includes, owner, contractor, design professionals. Subs can have their own IT administrators. It then creates an IT management team, which is composed of all the IT administrators. That team is supposed to set protocols and make decisions democratically, but if for some reason the team cannot agree on the approach, then the ultimate decision maker is the owner, who makes a decision on how the IT is handled. You have, under the ConsensusDocs, an IT management coordinator. And the management coordinator is involved in hiring a third-party service provider. You have a separate webmaster. I don't want to bore you with the details, but I do want to show that the ConsensusDocs approach is really very detailed, and in particular, I would think whether you use this document or not, it's worth it for anyone interested in how documents are transferred or produced to review this document. Get a copy and review it, particularly for Section 4 of the agreement, which is the system parameters, and it is a really comprehensive list of all the sorts of things that you need to think about as you are producing the documents, and as I'll get in my next topic, working on them together. Another important legal distinction between the AIA and the ConsensusDocs is how they handle the legal issues between the parties. Under the AIA, the receiving party indemnifies the other parties for any unlicensed use or modification of the documents. Under ConsensusDocs, there's a mutual indemnity of all the parties to all the other parties for damages arising from the failure to conform to the protocol. Now, indemnity itself is kind of its own world, and that's why Frank's next section will go into indemnities generally in the two documents.
Thanks, Tim. You know, indemnity is an important concern in any construction project agreement, and there are some important differences between how the AIA and the ConsensusDocs approach indemnity. So let me follow on Tim's comments with a few more notions of how the documents differ. The ConsensusDocs contain the standard narrow form indemnity, limited to claims for property damage, personal injury, sickness, and death, the kind of thing that you would expect to find. It is a mutual indemnity, with each party indemnifying the other to the extent of the indemnifying party's negligence. There's no duty to defend in the ConsensusDocs version, and you often see a duty to defend in indemnity provisions. But frankly, I think that's a helpful omission. You know, sometimes you don't want the indemnifying party to have the automatic right to defend you from the third-party claim. You may not trust the level of defense provided there. There is in the ConsensusDocs an ability to recover attorney's fees and cost of your dispute if you prevail. Now, on the AIA side, again, there is no mention here of any design professional indemnity obligation to the owner. In fact, the AIA 240 says that if the owner is required to pay the contractor more because of, for example, a design defect, the owner is prohibited from withholding money from the design professional to offset that loss unless the architect agrees to the withholding or the architect is found liable in a binding dispute proceeding. So you have a real absence of design professional indemnity in the AIA-B 101. I should mention that in the AIA-B 103, which is for large complex projects, there is a design professional indemnity of the owner and the owner employees in connection with third-party claims that arise out of the design professional's negligence, but that indemnity liability is limited by the amount of any available unused insurance coverage. There are a few other indemnity provisions in the ConsensusDocs. Carrie, next slide. The owner, there is an owner indemnity for the unpermitted use of design professional instruments of service, and that is after the project completion, the owner is given the right to use architect instruments of service to maintain, to renovate, to remodel, or expand the project. But if the owner engages in any unpermitted use, then the owner indemnifies the design professional for any adverse consequences that grow out of that unpermitted use. There's a separate design professional indemnity for negligence caused by project delays in the ConsensusDocs. There's a mutual copyright patent indemnity obligation. For example, if the design professional selects a patented or copyrighted system or method and doesn't have permission to use that system, then the design professional agrees to indemnify the owner and the contractors, and the owner makes the same indemnity promise to the architect with respect to anything selected by the owner. Again, in the AIA-B 101, it's silent with respect to any obligation, any indemnity obligation owed to the owner. But the AIA-B 101 does impose an indemnity obligation on the owner with respect to third-party claims arising from the unauthorized use of the architect's documents. I guess to sum up the indemnity situation in the two documents, if you're an owner or representing an owner, you will probably find better indemnity protections in the ConsensusDocs. Certainly if you're a design professional, it probably doesn't get any better than what you see on the AIA side of the indemnity ledger. Next slide, Carrie. Let's also talk about standard of care as it's defined in both these documents. And next slide there, Carrie. There are some differences between the B101 and the ConsensusDocs 240, both documents do describe the applicable legal standard of care imposed on the design professionals. And both definitions, although they may be worded somewhat differently, are consistent with the general common law standard of care imposed on professionals in the performance of services. And that standard is the skill and care required of like professionals in the area who are involved in similar projects. So different words, but not a big difference in terms of how they approach this standard of care or in the duty imposed. The ConsensusDocs added their express definition of a standard of care for the first time in 2011, but the addition of the language really didn't change anything. I think it simply made express what was already either implicit or implied by law. Next slide, Carrie. There is one difference that I should point out, or at least a potential difference in these two documents. There is language in the ConsensusDocs Article 2 which refers to the establishment of a relationship of trust and confidence by the architect in favor of the owner. And typically when you see that trust and confidence sort of language in a legal document, it signals the creation of a fiduciary relationship between the two parties. And I think it's certainly unclear yet how courts may interpret that language, but I could see an owner certainly arguing that a design professional has agreed to a somewhat higher standard of care in the ConsensusDocs than with respect to what you find in the AIA B101. And that relationship of trust and confidence could mean several things. It typically signifies a higher duty of loyalty and good faith. It requires that the fiduciary look out for the best interest of the other party. I think most owners would assume that the design professional owes them those duties anyway, but there is a difference between the common law duty of due care and a fiduciary duty. Many owners, I suspect, would prefer the potentially broader standard of care in the ConsensusDocs. However, the owner should understand that even if this language successfully creates a fiduciary relationship, there may not be insurance coverage for a design professional's breach of a fiduciary duty. And an owner should understand that potential insurance gap going into a project. Carrie, next slide. You know, in addition to establishing the architect standard of care, both of these documents address in different ways what I've called here a standard of completeness for the design professional's duty to provide a project design. If you compare the language from the two documents summarized on this slide, you'll see that the ConsensusDocs describes the scope of the architect's duties in creating a complete design in perhaps a more inclusive way. Whereas the AIA document, the design professional agrees to do only what the contract specifically requires, and the language in the AIA regarding the completeness of the design product is probably less demanding. I'm not going to spend much time on this. Again, it's not clear that there's a big difference between the two documents, but the language differences suggest to me that an owner may feel better protected by that ConsensusDocs language, both with respect to the standard of care and the required completeness of the design. Tim, let me give it back to you to talk about BIM.
All right. Thanks, Frank. And to follow up on one thing that Frank has highlighted, and I think I mentioned earlier, you know, the contracts are really just now catching up with some of these concepts. The law, I don't think, has quite caught up yet. The really interesting issue for Frank and me and other attorneys will be how, in a dispute, different experts hired by each of the parties to give opinions about what is the standard of care, what has been done, whether it has been met or not. That to me will be the area where you'll first probably see a difference in standard of care. But moving on to BIM, next slide, please, Carrie. This next slide is a repeat. I realize it's not a mistake. The same slide we started with, but now with BIM, we add a new concept. You know, we talked about how CAD had revolutionized things, and as the computers had more and more capabilities, it was not just about drawing lines, although it certainly does that. Now you can put information in those lines. Those lines can have information about what the line means, what it costs, what it does, how it works in the building. Interactive databases, cloud computing, where we are today, has really increased the potential for what I would call active collaboration among the multiple parties involved. Next slide, please. With the development of this collaboration, it's worth thinking about where we've come from and where we are. In some senses, collaboration's always been with us. I mean, back even before I was an architect, where labor was in some senses more of a profession perhaps than it is today, where you had apprentices and journeymen and masters, there was some amount of design that was actually left to labor. You know, the master plasterers would come up with the fancy plaster ceilings that some buildings had. So in a sense, they were collaborating on design themselves. There are other areas that are familiar to all of us where collaboration has always been present. Shop drawings. The lower tier suppliers produce documents, and they're producing documents that are showing how you're going to build the building. The architect hasn't done that, but you know, in these shop drawings, there's some amount of collaboration involved to make sure that what's being produced by the lower tier suppliers is in keeping with the design. Many types of specifications involve collaboration, particularly performance specs, at least in my view. Value engineering, a concept where, as typically seems to happen, you send it out for bids and it comes in high, and then you've got to have a team around the table trying to figure out how to bring the building in the budget. Design build, a very strong form of collaboration. Partnering, a concept that we heard a lot about maybe 10, 15 years ago, maybe not quite as much today. All of these have, I would say, led up to where we are today on a true collaborative approach where the technology allows all of the team members at all levels to have input early on. Next slide, please. BIM, as defined under the ConsensusDocs regime, I've got a quote there from the AGC of America publication on a contractor's guide to BIM, and I think it's worth looking at, you know, just what it is. It's a data-rich, object-oriented, intelligent, and parametric digital representation of the facility, from which views and data appropriate to various users' needs can be extracted and analyzed to generate information that can be used to make decisions and improve the process of delivering the facility. Next slide. The AIA has a very similar idea of integrated project delivery. I know that's not simply limited to BIM. It's in some ways an even broader concept because it's defined as a delivery approach that integrates people, systems, business structures, and practices into a process that collaboratively harnesses the talents and insights of all participants. And, you know, so the process has now become the key. Next slide. As between the AIA B101 and the ConsensusDocs 240, BIM under the AIA is through the E202. It's just the Building Information Modeling Protocol Exhibit. Under the ConsensusDocs 240, BIM is referenced in the 240 and notes that the participants are required to use BIM if the owner requires it. And it does have a separate BIM addendum, which is the ConsensusDocs 301. Next slide, please. As you compare these two approaches, these two documents, you will see that in many ways they are similar. Under the AIA, it is incorporated by reference into the other agreements. Under the consensus docs, on the other hand, it specifically says that it does not restructure any other agreements, but that the parties may either append or incorporate into the other documents. The AIA E202 gives a separate definition of BIM, defining the model. And the AIA, importantly, which we'll get to in just a minute, introduces the concept of the level of development in its approach to BIM. Under the consensus docs side, it's careful to state that it doesn't change the designer's obligations and it doesn't change the owner's warranties, anything with respect to the design. Next slide. Now, as I mentioned before, the AIA uses concepts in its BIM document that will be very familiar to architects. The level of development really, when you look at it, is very familiar because the 100 level of development is really what most architects and most designers I know would consider to be schematics. The level of development 200 is really more like design development. LOD 300 has accurate dimensions. It's much more like traditional contract documents, construction drawings. The 400 level of development includes within the construction documents, includes shop drawings, complete fabrication and detailing. And then the 500 level of development is reserved for altering or adding to the model. Again, these concepts will be very, very familiar to architects because that's the way things have been set up in delivering architecture for certainly as long as I can remember and before I was ever an architect. The Consensus Docs 301 is in some ways a blank slate beginning approach. And I think the reason it's done that way is that Consensus Docs, I believe, has strived to make it as flexible as possible, where it can use any level of building information modeling that you wish. You can go as far into the model as you wish. You can stay relatively far away from it if you wish, but either way, you pick and choose how you want to do it. It starts with a series of definitions that are important because the various models in some senses are similar to the AIA, in some senses are different. For example, you see the design model, which is section 2.6 of the Consensus Docs 301. That's the design model is defined as where the design has reached the level of a two-dimensional drawing. So it's not necessarily tied to schematics or DD. Construction model, you'll see defined there, is one which does include the dimensions, and it gets to the point where it includes the equivalent of shop drawings. Now that would be much like, in my view, the level of development 400 under the AIA. The Consensus Docs also has an interesting approach that you can sometimes have the ability to link the models together but not let the models affect each other. And that's the purpose of what the Consensus Docs calls a federated model. The models are linked together, but the individual models do not change. Now, why would you do that? I guess in my view, you might have to preserve where you were at a 50% review maybe. You can link all the models together, then you can move on and do other things. Consensus Docs has what's called a full design model, which includes architectural, structural, mechanical, electrical, plumbing. And then the model that really becomes the interactive model that everyone can have access to and utilize under the Consensus Docs is called the project model, which is defined as being a full design model plus one or more construction models. Again, I know from an architect's point of view, this terminology is going to be a little bit different, but it is designed to be, I think, as flexible as possible. Next slide. Under the AIA E202, it provides the protocols for who owns the model, what are the requirements of the model, how the model is managed. The ConsensusDocs 301 is, again, in my view, a somewhat more detailed document. It talks about the role and responsibility of an information manager, who we've seen before, that sets up the user accounts, sets the access rights and controls. You can read the rest of the slide there. Next slide. Another interesting thing to me about the AIA is for the model elements themselves, it attaches what is in essence a matrix called the model element table, and it divides the model into separate elements. And what will be very familiar to the architects is in using this table that it's careful to follow the CSI designation, the Construction Specifications Institute designations, which will be very, very familiar to designers. ConsensusDocs focuses instead on an execution plan. It defines the contact for the participants. It tells you how you identify, define, and update the content of the models. It gives schedules for delivery and update of the models. And then, again, the later portion of that ConsensusDocs 301 is, again, a document that I think is worth reviewing just to see what the different procedures and protocols might be in using BIM. And with that, we go to the ominous topic of termination.
Thanks, Tim. Let's talk about termination. And begin with the termination for convenience rights in both documents. You find in both the ConsensusDocs and the AIA document the right of the owner to terminate the services of the architect for the owner's convenience. There are identical 7-day written notice requirements with respect to that termination for convenience. But where the documents differ is in the categories of cost and fees that flow from a termination for convenience. The AIA document allows the architect to recover anticipated profits as well as what's called a licensing fee for the owner's limited use of the design professional's instrument of service after termination, while the ConsensusDocs substitutes what it calls a termination premium that's agreed upon by the parties up front and that takes the place of both lost profits and a license fee. I think the ConsensusDocs approach may provide an owner with a little more certainty regarding termination for convenience costs because you're not worried about the uncertainty of the determination of lost profits from a termination for convenience. Also, and this I found interesting, that in the AIA document, there's a mutual waiver of consequential damages for the parties except with respect to termination damages where there's no waiver of consequential damages by the design professional only. So again, I think you may get more certainty if you're an owner as to the cost of a termination for convenience with the ConsensusDocs, but with both documents, I think it certainly counsels in favor of some upfront discussion between the owner and architect regarding the likely consequences of a termination, even if that likelihood is remote. Next slide, Kerry. Termination for default rights are also present in both documents. Both documents provide mutual termination for default rights. The ConsensusDocs speaks of material breaches as justifying a termination, whereas the AIA talks in terms of a failure to substantially perform. There may not be a real difference here, just different language, although I think material breach may have a more defined meaning in the case law. And I suppose you could argue that failure to substantially perform may require something more than just a simple material breach. Not clear, different language, perhaps not real differences. Both documents do require 7-day notices. The ConsensusDocs specifically allows a right to cure in that 7-day period. The AIA doesn't speak of a cure right, but I think it's likely that one would be implied by law nevertheless. The other difference here is that the ConsensusDocs 240 requires that at the end of that 7-day notice period, if you really do intend to terminate, then you must confirm that intent in writing. And there's no similar provision with the AIA document. Next slide, Carrie. Let me talk for a minute about the architect's termination for default rights here. The ConsensusDocs contains a work continuation clause, type of thing that you commonly see in owner-contractor agreements, which will provide that the architect in this case will continue to work during the pendency of any dispute, and the owner will continue to make payments for at least undisputed sums. But in addition to this, in the ConsensusDocs, the design professional has a right to terminate for a material breach. So the manner in which that work continuation clause will coexist with the architect's right to terminate for a material breach is perhaps somewhat fuzzy. But I think, again, if you're an owner, you would probably much prefer to have a work continuation clause in your contract. In the AIA B101, there is no work continuation clause. And in the AIA document, the architect also has the right to suspend services after 7 days' notice for a failure to make a payment, which is an option in addition to termination rights. The design professional in the AIA B101 also has the right to terminate the contract if the owner suspends the project for more than 90 days for any reason, provided it's not the fault of the design professional. That's termination. Let's look at dispute resolution, which is somewhat different between the two documents. Go on to the next one. Thanks, Gary. This first slide is something of a dispute resolution overview of how the two different documents approach disputes and the resolution of disputes. Most of you, I'm sure, are probably familiar with the AIA dispute resolution process. It has changed, but it's changed only slightly since the 2007 version of this document was published. In the AIA, you still are required to mediate disputes, and then those disputes, if not resolved, are subject to either arbitration or litigation or some other dispute resolution procedure depending on what the parties agreed to in the contract. In the AIA document, it is a check-the-box process for choosing between arbitration or litigation or writing in some other disputes procedure. And if no box is checked, which sometimes happens, the default process now is litigation. It used to be arbitration, and the pendulum has swung the other way. The default dispute process is now litigation in the AIA document. The ConsensusDocs scheme provides some additional options, and the other thing that I think the ConsensusDocs does, which is different, is that it strongly encourages a quick dispute resolution. Let's go to the next slide, Carrie. Let's look at the ConsensusDocs scheme. This flow chart is something of an overview. It provides you with a basic outline of how the ConsensusDocs moves a dispute first from party representative discussions to senior executive discussions, and then to either a mitigation procedure or mediation, and then to arbitration or litigation. But let's go to the next slide, and I'll walk you through exactly how that process works. The ConsensusDocs mandates 2 levels of informal settlement discussion in connection with a dispute. First, the party representatives are required to have direct discussions, And if those party reps can't resolve a dispute within 5 business days of the first discussion, then senior executives of the two parties have to meet within 5 business days of being informed that the party reps were not successful. And then if the matter is not resolved within 15 days from the first discussion, and keep in mind when I say first discussion, I'm talking about the first discussion between the party representatives. So if the matter is not resolved within 15 days from when all this discussion process first began, then the dispute is submitted to either any selected dispute mitigation procedure, which could be either a project neutral or a dispute review board, for what is a non-binding finding that must take place within 5 business days of the referral of that dispute, unless good cause is shown to extend the time. Or if the parties haven't selected a dispute mitigation procedure, then the matter goes from the senior executive discussion to mediation. And that mediation is required to take place within 30 days of the matter being first discussed, again, first discussed by the party reps, and must be concluded within 45 days of that first discussion. And if the dispute is not settled as a result of that mediation procedure or the dispute mitigation procedure, then the dispute goes to either arbitration or litigation for final resolution. Now that's a fairly complicated and certainly accelerated disputes procedure. ConsensusDocs really don't allow a dispute to linger for long, and I think certainly that's to be commended. The industry would like to see disputes resolved quicker than they are now and less expensively. But in some cases, I think involving complex issues, the short time frames that you see here probably are not sufficient to allow a real opportunity for an informal settlement process. Of course, the parties can amend these time frames, either pre-contract or when a dispute arises to suit that particular dispute. Carrie, next slide, please. The AIA process for resolving disputes, as I said, is fairly traditional and hasn't changed much, so I won't spend much time here. The contract does allow the owner the option of designating the architect as the initial decision maker with respect to owner-contractor disputes. That's always, or in recent years, has been present in the AIA documents. The only change here is that the initial decision maker role for the architect is now an owner option as opposed to a default requirement. Mediation is a condition precedent to arbitration or litigation. The AIA refers you to the AAA rules and to AAA administration. And although you can demand mediation contemporaneously with an arbitration demand or filing a lawsuit, mediation is given 60 days in the AIA scheme of things to work its magic. So probably less here of a contractually mandated sense of urgency in the resolution of disputes with the AIA procedure, although the 60-day period for mediation does push the process along with some speed. Next slide, Carrie. I'm going to go quickly through the next 2 slides, but here are some other aspects of the dispute procedure that you will see, and you can see some of the differences between the 2 documents approach. You've got prevailing party ability to recover fees with the ConsensusDocs, no similar provision in the AIA documents. And with the ConsensusDocs, you are referred to the AAA rules for the administration of a mediation or arbitration, but you are not required to use the AAA as the administrator of the mediation or arbitration. Next slide, Carrie. And then quickly on consolidation and joinder, and we will probably get to some questions here in the last 10 minutes. You know, it's rare on a construction project for a project dispute to involve only 2 parties. And so particularly for the owner and contractor, it may be important that the contract make it easier to join other parties to an arbitration for instance, or to consolidate related arbitration. And without taking the time to walk you through these slides, and you certainly can look back at them, let me simply say that the consensus docs make it easier to join parties involved in the dispute or to consolidate related arbitrations. The AIA documents impose some conditions precedent that have to be satisfied both to consolidate two arbitrations or to join another party to a pending arbitration. And that AIA scheme can make it somewhat more difficult to get everybody who's involved in a dispute in the same proceeding, which can have the impact of either resulting in multiple arbitrations or litigation matters, and in increasing the cost necessary to get to a final resolution with everyone. Carrie, let me turn it back to you, and we can take some questions.
That sounds great. Thanks, Frank. We do have a couple of questions here. If anyone else has questions, now is your time to put it in our questions box, and we'll ask the speakers to address it. So we'll start off with a question here. In Indemnity Article 7.1, please expand on, in quotes, architect indemnifies owner, constructor, and others at the site, end quote. Is not the constructor responsible for activities on the site?
Well, are you referring to the consensus docs? Is that a consensus doc? It sounded like it. Reference 7.1.
Well,
I think certainly the constructor is responsible for activities on the site, for safety, for the consequences of the constructor's negligence. The difference in the two documents in their approach to indemnity here is that in the consensus docs, the architect is required to indemnify the owner's employees, and others at the site for the consequences of the architect's negligence. So if others at the site are harmed by the architect's negligence, then there is an indemnity obligation that is created there. It doesn't mean the architect is responsible for anything that may happen on the project site, but only to the extent of the architect's negligence or the indemnity obligations created. I'm not sure if that answered the question.
I think, Frank, I think that's right, because on indemnity provisions, particularly for the non-lawyers on the line, what you always have to look to is what specifically are you indemnifying others from? It's not a blanket indemnity, because a blanket indemnity, I think, is rarely going to be enforced. It's only to the extent that the document says they arise from the performance or the failure to perform services under this agreement, but only to the extent caused by the negligent acts, as Frank mentioned, or omissions of the designer. So you're not indemnifying for everything on the planet, but you are indemnifying if, you know, for some reason, something that you've done in the performance of your services results in some harm to others.
And Tim, it's also limited to bodily injury, sickness, death, property damage.
Right.
So that's a further limit on that indemnity obligation.
Super. Okay, our next question is, why would an architect willingly agree to raise the standard of care?
That's a very good question. I mean, and I'm sitting back here. I'll put my old architect's hat back on. I wouldn't want to do that. But the crux of the matter is, in like any agreement, any contract is about allocation of risks and responsibilities. And if an owner is seeking to hire an architect who's willing to take on that higher level, then the architect's going to have to do it, or they're going to have to negotiate some different approach to it. And I think it's also important, I'll let Frank expand on this, but you know, it's really not exactly clear that this duty of this position of trust and confidence really takes you far beyond what an architect's duties would normally be in the first case.
No, I think that's absolutely right, Tim. I wanted to point out the presence of the language because it's different than what you find in the AIA documents, and at least might support the argument that some higher standard is being created. But it's certainly not at all clear that that's what you have there. And it's something that, you know, I'm sure most architects would want to discuss with an owner going into a project.
And our next question seems to follow up on that. A fiduciary duty may not be insured, but it seems hard to make the case since the professional services language of the insuring contract will include all the duties that the professional must provide as incident to his provision of his licensed professional services. Therefore, it could be argued that there is no increase in the standard of care, which may put the fiduciary duty outside of coverage. The registrant, the attendee, was interested in your viewpoint about this.
Well, I'm not sure that I can really add to what I've already said there. I mean, I think that's a good point. It may or may not be covered by insurance. I have heard insurance companies tell me that that level of fiduciary care will not be covered by an architect's typical E&O policy. I have never tested that statement, but I hear it a lot. Tim, do you have any experience with that?
I have not. I do think, having been through several coverage disputes and other disputes with insurers on construction projects, it's certainly not unusual that the insurance company would say that. I don't think that concept has really been tested yet, because I can see courts coming down the other way. I don't have a case where that's happened.
And I think that's a good point, that it hasn't been tested, and the insurance companies have a vested interest in saying that no, it won't be covered. They say no, everything's pretty much not going to be covered if they can. And I think one of the things to look at in the overall concept of the projects and the way the industry is changing is, what is your owner expecting, no matter what's in the contract, in order to build positive relationships and hopefully long-term relationships? The fact that something, no matter what it is in a contract, you may be contractually correct, but if the owner is not truly aware of or cognizant of what the situation is, you may have lost future business. Let's see here. So we have, go ahead.
Terry, I was just going to add that, you know, not every risk needs to be insured, and there are parties every day who will contract for things which they expect and want to have with the understanding or without really being deterred by the fact that it may not be an insured risk. It's still an expected contract performance measure.
Good comment. A couple more questions here, and we have a few minutes left. Are you aware of any reported decisions enforcing the dispute resolution process found in ConsensusDocs? I am not aware of any.
I'm not aware of any, but I'm also not aware of any state in which you could not agree to the type of disputes procedure laid out in the ConsensusDocs. I mean, I don't know of anything there that is so unusual that it couldn't be agreed to as a matter of contract. There's not much there that is new and different. There are a lot of options presented, and the at least initial time frame for a dispute is laid out in the document is quick. But if the parties agree to it, I feel confident it would be enforced.
The other thing I would add, Frank, is it's not at all unusual, regardless of the time frames, whether they're quick or not quick, for parties to mutually agree, even though they're in a dispute context, that, hey, we cannot really get to this at this time. We can agree among ourselves that we will not enforce strictly that deadline in order to sort of maintain the peace, keep the project going, but also get to a dispute resolution, but get to it in a time frame that works better for the parties.
Right, and the time frames in the consensus docs that carry the short time frames are really the preliminary, informal. You have to agree, you have to reach a settlement agreement in order to solve this, steps in the process. Once you get past those to either arbitration or litigation, then you're back in the normal situation that parties find themselves when they agree to arbitrate or litigate.
Well, I have us at 3 o'clock, but I'm going to ask one last question here that came in, and it is, what are your recommendations when the owner does not use either AIA or consensus docs but wants DIM?
I'll go ahead and say that even if you're using neither the AIA nor consensus docs, which most likely is going to mean you're using a custom drafted agreement, which again is not at all uncommon for owners to have their own set of documents that they use, I still think the consensus docs approach on BIM gives you a lot of leeway to be very flexible, gives you a lot of choices, and just personally, I like the fact that it lists a lot of options that I probably would have never thought about, a lot of details about the process that I would have never thought about, and there would be absolutely no reason why a consensus docs form couldn't be used along with some other form, as long as when you're bringing the consensus docs form in, you're clear about how it governs, whether it changes anything in the underlying agreements or not, that sort of thing.
And I would say you are both too humble. How I would answer that question is that no matter whether or not you're using an AIA or consensus docs or a custom form, you always need to seek counsel, local counsel, to make sure what you've got in there is what you mean and that type of thing. And so with that, I want to thank you, Tim and Frank, for your fantastic, informative presentation. I want to thank our participants for joining us today. We hope that this webinar helped you learn about some of the differences between consensus docs and AIA standard contracts. Please take a moment to complete the evaluation form that we'll email to you along with a copy of the PowerPoint and a copy of the recording from today's presentation. Your feedback will help us plan future educational events. This now brings our program to a close. I hope you all have a wonderful day. Thanks again, Tim and Frank.